I appreciate the comments of my distinguished colleague from Texas. As usual, he's right on, and one of the great leaders on trying to balance the budget through a constitutional amendment. And I personally really appreciate his efforts and his expertise in doing that. On a different subject, I rise today to speak about the need for the Senate to do its job regarding the Supreme Court vacancy created by the untimely death of Justice Antonin Scalia. The Constitution gives to the President the power to nominate Supreme Court justices, and President Obama has exercised that power by nominating Judge Merrick Garland. The Constitution gives to the Senate the power of advice and consent, and it is time for the Senate to do its job. The soundbite, "do your job," is catchy, quotable, and short enough fit in very large letters on a chart that Democratic senators bring to this floor. Rarely, however, have so few words been so misleading for so many. This cliche begs but does not answer the most important question. What is the Senate's job regarding the Scalia vacancy? When Democrats and their liberal allies say, "do your job," they really mean do as we say now, not as we did then. Saying that would be more honest, but then no one else would be persuaded by it. So they say that the Constitution provides the Senate's job description, requiring a prompt Judiciary Committee hearing and a timely floor vote. There may be a Constitution somewhere that says such a thing, but it's certainly not in our Constitution, the Constitution of the United States, that each of us has sworn an oath to support and defend. In a way, I'm not surprised that liberals would use a made-up, fictional Constitution to pursue their political goal. After all, they favor judges who do the same thing. From the time he was a senator serving in this body, President Obama has said that judges decide cases based on their personal empathy and core concerns and vision of how the world works. My gosh, if that was the case, any philosopher could be a Supreme Court justice. He has nominated men and women who believe that judges may change the Constitution's meaning based on things like cultural understandings and evolving social norms. Give me a break. The kind of judges that liberals favor seeing unwritten things in our the kind of judges that liberals favor see unwritten things in our written Constitution. They discover things between the lines of our written charter that come not from those who drafted and ratified the Constitution, not from the American people, not even from the judges' own, but from the judges' own imaginations. If the Constitution we have, the one that our fellow citizens can read, suits them, then activist judges will use it. If not, then activist judges will make up a new Constitution that is more useful to their purposes. America's founders fashioned a system of government with built-in limits, including a defined role for unelected judges. The Supreme Court observed in the famous case of Marbury versus Madison that the Constitution is written down so that these limits will be neither mistaken nor forgotten, and is intended to govern courts as much as legislatures. The activist judges that liberals favor reject those limits. They look at written laws such as the Constitution and statutes merely as a starting point, as words without any real meaning. Their oath to support and defend the Constitution is really an oath to support and defend themselves, since in the long run their Constitution is one of their own making. So I'm hardly surprised that today Democrats and their left-wing allies turn to a fictional Constitution when telling the Senate to do its job. That Constitution, however, simply does not exist. The real Constitution, Madam President, leaves to the President and to the Senate the decision about how to exercise their respective powers in the appointment process. And what is the Senate's job regarding the Scalia vacancy? The Senate's job is to determine the best way to exercise its advise and consent power under the circumstances we face today. Thankfully, we are not without guidance in deciding the best way to exercise our advice and consent power regarding the Scalia vacancy. We can, for example, look at precedent. It hardly takes a law degree to know that a precedent is more legitimate if it is more similar to the situation before us. Comparing apples and apples is more helpful than, say, comparing apples and rocks. That's just a matter of common sense. Candidly, the fictional claims offered in recent days suggest that some of the lawyers among us could benefit from even more common sense. Over the years, the Senate has considered nominations in different ways at different times, depending on the circumstances. Consider these precedents with great bearing on the current circumstances. The Senate has never confirmed a nominee to the Supreme Court, to a Supreme Court vacancy, then opened up this late in a term-limited president's time in office. This is only the third vacancy in nearly a century to occur after the American people had already started voting in a presidential election. And in the previous two instances, in 1956 and 1968, the Senate did not confirm a nominee until the following year. And the only time the Senate has ever confirmed a nominee to fill a Supreme Court vacancy created after voting began in a presidential election year was in 1916. And that vacancy arose only because Chief Justice Charles Evan Hughes resigned his seat on the court to run against incumbent President Woodrow Wilson. There is also another precedent that has received little attention but is worth considering. President John Quincy Adams nominated John Crittenden to the Supreme Court in December 1828, after Andrew Jackson won the presidential election. The Senate by voice vote rejected an amendment to a resolution regarding the Crittenden nomination that asserted it is the duty of the Senate to confirm or reject a president's nominees. In one of its reports on the confirmation process, the Congressional Research Service discussed this vote and concluded, quote, "By this action, the early Senate declined to endorse the principle that proper practice required it to consider and proceed to a final vote on every nomination," unquote. I believe that the precedents, such as they are, support the principle that the Senate must decide for itself how to exercise its power of advice and consent in each situation. We have another source of guidance for how to exercise the advice and consent power in the particular circumstances of the Scalia vacancy. In 1992, another presidential election year during divided government, then Judiciary Committee Chairman Joseph Biden, now our Vice President, addressed this very issue. He recommended that, Senator Biden recommended that, if a Supreme Court vacancy occurred that year, the entire appointment process, both nomination and confirmation, should be deferred until the election season was over. Now, here's what he said in a lengthy interview with the Washington Post, and you can read it here. Quote, "If someone steps down, I would highly recommend the president not name someone, not send a name up. If the president did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee," unquote. Chairman Biden also explained the reasons for this recommendation. He said, for example, that any election year nominee would be caught up in a, quote, "power struggle," unquote, over control of the Supreme Court. Boy, he was prescient. In that interview, he also said, and let's refer to this chart right here, quote, "Can you imagine dropping a nominee after the decisions that are about to be made by the Supreme Court into that fight, into that cauldron in the middle of a presidential year? The environment within which such a hearing would be held would be so supercharged and so prone to be able to be distorted." Now, a week later, Chairman Biden addressed the Senate about the confirmation process and further explained his recommendation for deferring the appointment process should a Supreme Court vacancy occur. he repeated his recommendation regarding how to handle a Supreme Court nomination occurring that year. And let me just refer to this chart, and you can read it. Quote, President Bush should consider following the practice of a majority of his predecessors and not name a nominee until after the November election is completed. If the president presses an election year nomination, the Senate Judiciary Committee should seriously consider not scheduling confirmation hearings on the nomination until after the political campaign season is over, unquote. Chairman Biden again explained the reasons for this recommendation. The confirmation process had degraded in the wake of controversial nominations, and the presidential campaign that year looked to be particularly bitter. As a result, he said partisan bickering and political posturing would overwhelm the serious evaluation required. In addition, the presidential election session was already well underway, and different parties controlled the nomination and confirmation phases of the appointment process. Madam President, Chairman Biden could have been talking about 2016 instead of 1992. In fact, each of the factors leading to his recommendation for deferring the appointment process in 1992 exists in the same or greater measure today. Not a single Democrat objected to Chairman Biden's recommendation to defer the appointment process. Not one. Not one Democrat. If what Democrats say today is true, that the Constitution requires a prompt hearing and a timely floor vote for every nomination, surely someone, anyone, would have said so back in 1992. Not so. My colleagues will search the 1992 congressional record in vain for the slogan, "Do your job." It appears that a different Constitution was in force in 1992 because no Democratic senator or leftist organization insisted that the Constitution required a prompt hearing and timely floor vote. No one claimed that the Senate would be shirking its constitutional duty by following Chairman Biden's recommendation. The first step in exercising our power of advice and consent regarding the Scalia vacancy, then, is to decide how best to do so in the circumstances we face today. Precedent generally and guidance from past Senate leaders specifically counsel strongly in favor of deferring the confirmation process until after the presidential election season is over. That is clearly the best course for the Senate, the judiciary, and of course the nation. That conclusion is reinforced by another important factor. Elections have consequences. Democrats and their left-wing allies also use that axiom, but want people to believe that 2012 was the only election relevant to the Scalia vacancy. They want people to believe that because President Obama was reelected in 2012, he should be able to appoint whoever, whomever, whenever, however he likes. That idea must appear in another provision of the Democrats' fictional Constitution because, once again, the real one says no such thing. The 2012 election did give the president the power to nominate, and he can exercise that power however he chooses until his final minutes in office next January. And I would uphold that right. He has exercised that power by nominating Judge Srinivasan. The 2012 election, however, was not the only one with consequences for the judicial appointment process. The 2014 election, for example, had tremendous significance for the Senate's power of advice and consent. The American people gave control of the Senate and therefore control of the confirmation process to Republicans. Here, too, we may find some guidance from our friends on the left in addressing this circumstance. President Ronald Reagan nominated Judge Robert Bork to the Supreme Court in 1987. This was 3 years after his reelection and a year after the Senate majority changed hands. Here's how the New York Times addressed the argument that elections have consequences. You can see it right on this chart. Quote, "The president's supporters insist vehemently that having won the 1984 election, he has every right to try to change the court's direction. Yes, but the Democrats won the 1986 election. regaining control of the Senate, and they have every right to resist, unquote. The same circumstances obviously exist today. By the way, no one should waste time wondering if the New York Times has applied the same principle today. It, of course, hasn't. In addition to 2012 and 2014, the 2016 election will have tremendous consequences for the American people and the courts. It will give the American people a unique opportunity to express their opinion about the direction of the courts by electing the president who nominates and the Senate that gives advice and consent. Republicans and Democrats, conservatives and liberals, have very different views about the kind of judge that America needs. Justice Scalia represented a defined, modest approach to judging, while, as I mentioned earlier, President Obama has advocated an expansive and activist approach. I've served on the Judiciary Committee longer than all but one senator since the committee was created 200 years ago. And one thing is clear to me. The conflict over judicial appointments is a conflict over judicial power. The two models of judicial power or judicial job descriptions that I have described have radically different consequences and implications for our nation and our liberty. The American people have expressed increasing concern about the Supreme Court's direction since President Obama was elected. Most Americans, for example, believe that Supreme Court justices decide cases based on their personal views and object to them doing so. With Justice Scalia's untimely passing, the American people now have a unique opportunity to have a voice in charting the path forward. Mr. President, I cannot conclude today without addressing what is widely understood to be part of the President's strategy in nominating Judge Garland to the Scalia vacancy. The Senate confirmed Judge Garland to the U.S. Court of Appeals by a vote of 76 to 23 in 1997. This, I take it, is supposed to suggest that the Senate should do likewise regarding Judge Garland's nomination to the Supreme Court. So there is no mistake. Let me say this as clearly as I can. The confirmation process regarding the Scalia vacancy will be deferred until after the election season is over for the reasons I have explained. That decision has nothing whatsoever to do with the identity of the nominee. And the Republicans made our decision known weeks ago before the president had chosen anyone. But I also want to emphasize that the considerations relevant to an individual's nomination to one position do not necessarily lead to the same conclusion regarding his nomination to another position, especially the Supreme Court. Here, too, I want my colleagues to be aware of guidance we can draw on from the past. In 1990, then-Chairman Joseph Biden presided over the hearing on the nomination of Clarence Thomas to the U.S. Court of Appeals for the D.C. Circuit. He said, and I'll refer you, well, we don't have a chart on that. He said, this is what Chairman Biden said, quote, "There is a fundamental distinction between what is required of and should be sought of a circuit court judge and a district court judge and a Supreme Court justice," unquote. He was right then, and it's right today. Democratic senators made the same point in 2005 when they sought to distinguish their earlier support for John Roberts' appeals court nomination from their intention to oppose his Supreme Court nomination. Senator Schumer, for example, our distinguished senator from New York, called it a whole new ballgame. He said, quote, "You've got to start from scratch," unquote. Senator Leahy agreed, saying that the Supreme Court is different from the lower courts. I couldn't agree more. Add this to the list of standards that my Democratic colleagues have reversed now that the partisan shoe is on the other foot. Senate Republicans have explained repeatedly and in detail why the best way to exercise our advice and consent power in this situation is to defer the confirmation process. That conclusion is completely unrelated to whether the president chooses a nominee or, if he does so, who that nominee is. President Obama could have followed Vice President Biden's 1992 advice and deferred a nomination to fill the Scalia vacancy. He chose not to do so. For the reasons I have discussed, precedent, past guidance, and the consequences of elections, the Senate should follow that advice and defer the confirmation process for the good of the Senate, the judiciary, and the American people. I'm tired of all the screaming and shouting that goes on in this most horrific of all presidential elections, at least in modern times. I'm just tired of it. And I'm really tired of politicizing the court, which is what my colleagues seem to really love to do. So I don't think it's unreasonable to ask our colleagues to put this off until after the next president is elected. That way, whoever that person is, that person will have the power to nominate whoever that person wants to. We'll still have the right to advise and consent, and that may be problematic to the next president. But the fact of the matter is that it's important that we recognize that it's not any person that we're against. It's the process and integrity of the court that we're for. And this particular election season is the most toxic of my 40 years in the United States Senate. And they're always well argued, but this is toxic. And I personally do not want to see the court demeaned during this particular time. Mr. President, I suggest the absence of a quorum.
Clerk will call the